It's an honor and a pleasure to be moderating and working with Dealmakers. We have a great panel today, and so I would like to jump into this and introduce our speakers with our panelists with brief bios. They all have incredible educational experience backgrounds, but we won't be able to go into that in detail. But we have with us today David Latt, who's a noted lawyer turned writer. David was the founding editor of Above the Law and now the founder and sole writer of Original Jurisdiction, a newsletter blog focused on law and the legal profession. We're also pleased to have with us William Marra, who is an investment manager at Validity Finance, has a deep background in litigation as clerk for Justice Alito at the Supreme Court. Also joining us is Ina Popova of Debevoise and Plimpton, who is a leading international lawyer focusing on international arbitration, litigation, and public international law, admitted to practice in Paris and New York. Really pleased to have you with us here this morning. So now I'd like to start off, and I'd like to start with you, David, with a question and then open it up to the panel for discussion. David, you've been observing the impact of COVID on litigation from a number of perspectives, including decreases in filings, COVID-related litigation, and perhaps substantive changes in law due to COVID. So let's start with you. What are some of your key observations? David, we're there you go.
And I still can't get the unmute correct.
We got that.
We
got that.
In my defense, this is Air Meet's a new platform. I've been unmuting myself on Zoom correctly for.
We've had to have one glitch this morning, and you got us through it. Thank you. Good job.
It could have been worse. So anyway, thanks, Charles. Yes, that's correct. I've been monitoring litigation from the perspective of a journalist who writes about law in the legal field, and fortunately, there is some good data on some of the effect of the pandemic on litigation. So, for example, Lex Machina, the legal analytics platform owned by LexisNexis, has gathered some data about how the pandemic has affected civil litigation. And I'll focus on civil litigation here. That's the focus of our discussion today, certainly given the nexus with litigation funding, and criminal litigation has all kinds of other complexities, things like the Speedy Trial Act, et cetera. So let's focus on civil litigation. So in terms of filings in the federal trial courts, federal district court, Lex Machina tracks all of this, and I'm going to refer to their findings for 2020 over 2019. Certainly, we're in 2021, but there's always a lag time in terms of gathering and coding the cases. But we really do have pretty solid data already on 2020 and how it compared to 2019. So case filings in 2020 in the federal district courts compared to 2019 fell by about 8%, excluding product liability cases, and I'll talk about those in a sec. This is a significant drop-off, but it's maybe not as huge as some people might have expected at the start of the pandemic. One reason I think it's maybe not as big as some people expected is that we also had, despite the closure of the courts in March and April, we also had an increase in cases related to COVID. So there were a number of cases that were filed that would not have been filed but for the pandemic. And about 4% of federal district court filings in 2020 are what you could call COVID-19 cases. So Lex Machina categorizes the different types of filings based on subject matter, and filings decreased in all areas except for the handful I'm about to name. Products liability, insurance, contracts, securities, and patent. Products liability is a bit of an outlier because there was a large MDL, multi-district litigation case set involving earplugs. Some of that litigation still going on. You may have been following the 3M trials, but that resulted in the products liability space in something like a almost 400% increase in case filing. So if you back out the products liability, there has been this drop in filings. And if you look at the types of cases where there were increases, those are sort of a good indicator of the types of areas where there was a lot of activity during COVID. In insurance, there was a 14% increase in cases. A lot of that was actually litigation over business interruption policies. There was a 6% increase in securities cases. And, of course, we had that big drop in the stock market in the spring, and that often leads to more securities litigation. In terms of the types of claims, Harvard Law School's Corporate Governance Forum has done some research on this. And for example, there were claims of inadequate disclosures, of risks to business models related to the pandemic. There were also lawsuits over companies that allegedly that made allegedly misleading statements about treatments or vaccines that they were developing related to COVID. And of course, there was also a small increase in derivative actions alleging that directors didn't adequately fulfill their responsibilities. There was a small increase, about 2%, in contract cases. I'm kind of surprised this wasn't larger, but I think it reflects that a lot of parties were willing to work things out outside of litigation, given the extraordinary nature of the pandemic. Much of that contract litigation related to canceled events. There was some litigation related to so-called force majeure clauses, provisions that excuse a party from performance based on some unforeseen circumstance. And then, of course, one issue that definitely came up during the pandemic was, in the transactional context, what constitutes a material adverse change or a material adverse effect, allowing parties to walk away from a deal. But that actually didn't lead to that much litigation. A lot of it, I think, got worked out contractually. So overall, as Charles mentioned, there definitely was this decrease in cases overall, but some areas saw increases related very much to factors driven by the pandemic.
Well, thank you, David. Would anyone like to comment on that or share some observations? Will, can you tell us your thoughts kind of with respect to maybe how that's impacted you?
Yeah, I think David's made some great points there, and I think maybe there's a point I'll make about delay as well. That in addition to kind of the number of cases that have been filed, what we've seen anecdotally, and this is borne out by the data as well, is the pace of justice has slowed. So a lot of cases, especially cases that were kind of ready for a trial, and in particular ready for a jury trial, those were postponed at first indefinitely, and we start to see some kind of coming back online. But I think that's been a very significant factor we've seen. And if we think about one implication of that, and I think it's one that the lawyers listening will be familiar with, it's that procedure in many ways influences substance. Procedure influences case outcomes, right? So the more hoops you have to go through as a plaintiff to get to the end of the case, and the more time it takes to get there, the more likely you are to be financially exhausted and resolve the case, settle the case maybe for less than the full value of the claim. Another way to think about that is that delay, on average, sort of ends up being a wealth transfer from plaintiffs to defendants. And that's significant from my point of view as a litigation funder, because one of the main problems we're trying to solve at Validity is exactly this problem of the disparity in financial resources that you sometimes see. That's exacerbated by delay, and it's a problem that's become more acute during COVID. And frankly, it's not a problem that ends right when you get that second shot of Pfizer. It's a problem that's going to continue because this backlog, especially cases.
Well, thank you, Will. That's there's some clear impact being seen there. You've been able to, thank you for articulating that. I'd like to turn to Ina now with another question. Ina, as a specialist in international dispute resolution, I imagine you've seen some significant changes in the process, perhaps the type of cases. Can you fill us in on your observations and touch on the transition, perhaps to virtual proceedings in the international regime?
Thanks, Charles. Yes, I'd be happy to. So some of the considerations that Will and David were raising play out a little differently in the international sphere. So first of all, at a very basic level, because there's no courthouse, no physical courthouse, there's no physical courthouse closure. And so in international arbitration, some of the disruptions that we might have seen due to physical closures, we really haven't felt them. And in fact, if you look at some of the sort of the anecdotal feeling, which is borne out by the data to the extent we have it from last year, is that there's actually been an increase in case filings. So, and I'll touch on those 2 points, both on the delay and has there been a slowdown or not in the amount of cases. So some of the data for 2020 is still coming out, but what we have shows that many of the leading international arbitration institutions actually had their busiest year either ever or in the last several years. So, for example, the ICC, International Court of Arbitration, where I sit on the court, reported the highest number of new cases registered last year since 2016. The LCIA, the London Court of International Arbitration, reported an 18% increase in the number of cases administered under their rules. And SIAC, the Singapore International Arbitration Center, reported a 125% increase from 480 cases filed in 2019 to over 1,000 cases filed in 2020. So no slowdown in international arbitration. We've certainly felt it, and the data sort of coming out and supporting that. In terms of kind of the pace of proceedings, a lot of, because international commercial arbitration is typically confidential, it's hard to have a sort of overall sense of how things are going. But I will say that in a way, anecdotally, things might actually have accelerated for this very practical reason that nobody needs to travel anywhere to do a virtual hearing. And in international arbitration, where you have, if you've got 35 participants, they've probably been to 50 different countries in the last 5 days, finding a time to get people physically together for a hearing, so all your tribunal members, counsel, the parties, your witnesses, your experts, is often quite a game of Tetris, which is why we try to set up all of the hearing, set the hearing dates, set the procedure at the very outset of the case, so that you know exactly when things will be happening and people hold that time. So we're no longer dealing with, we have to, in many cases, not in all cases, but in cases where the hearings have gone virtual, and we can talk about that as well, we're not, the sort of practical, logistical difficulty of finding time on people's calendars has been attenuated a little bit. Now that's been replaced, of course, with having to manage the 35 different time zones that people are in, but we can talk about that a little bit, I think, as well. In terms of the kinds of cases that we're seeing, again, mostly anecdotally, but we a lot of the increase in cases is attributable to commercial contracts that were cancelled or not performed during the pandemic. So, as David was mentioning, arguments of force majeure or hardship, MAC clauses, MAE clauses, or even events of frustration that have occurred due to government measures. And we know that in part sort of through anecdotally the evidence, the information that we're hearing, but also because some institutions publish information about when the contract was concluded that gave rise to the dispute. And we're seeing that in a lot of these cases filed last year, the contracts were concluded within the last year or 2 years. So we can make an educated guess that perhaps there was some disruption in that performance recently that led to the finding.
Well, thank you. Ina, does anyone have any comments?
Yeah, I'll add maybe a quick word, because I think this trend that Ina has highlighted is so fascinating. Almost this divergence between arbitration and courts in terms of one accelerating and one slowing down. And it's interesting to kind of think through why that might be the case. I think one possible reason is arbitration is fundamentally private dispute resolution, right? You hire your own judges who are focused on your own case. You don't have to get in line behind a whole bunch of other people. And I think as we kind of come out of COVID, right, to Ina's point about the increase in filings, I think it's going to be really interesting to see if this kind of established trend towards having these arbitration dispute resolution provisions in contracts, if that's going to be even more accelerated, right? Because as people say, hey, the court system just takes too long, you might have more of a trend towards Ina's world, both international arbitration and domestic arbitration. And then kind of from the funding perspective, those cases are oftentimes better candidates for funding because, as Ina knows, an arbitration might take 2 or 3 years of commercial arbitration, whereas if you're in federal court or state court in the United States, 4, 5, 6 years, those are not unheard of timelines.
Well, I think that's a very likely outcome and maybe very beneficial to both, certainly to plaintiffs, but we'll see. David, do you have some comments?
Yeah, I just wanted to add on the point of delay that Will was talking about. We do have some data on resolutions in civil litigation. Lex Machina tracks so-called findings at the end of a case, like a finding of patent invalidity, a finding of contract breach or no contract breach. It's a little bit hard to sort of track the increase in durations because As we know, cases take hundreds of days to go through the system anyway, so it's hard for us to have a sense of that. But we do have a sense of the decline in resolutions of cases in 2020. And basically, in the federal trial courts, resolutions were down by about 12%. Again, there were different categories. So, for example, default judgments, so findings entered after a default judgment, those were down by only 7%. Findings after a trial were down by the largest amount, 51%. And I would have even expected that to be larger. It may just be a comment on how few trials we have in our system anyway. Really, arbitration in many ways is the new trial. When I talk to litigators and they say I had a trial, often they're referring to an arbitration because, you know, a jury trial in court is so rare. The last thing I'll just mention is on state courts, which, you know, they don't tend to be as often the cases that are handled by large firms or that get funding, but they're, you know, sometimes you're in state court. The National Center for State Courts has some data on that. They tracked about a dozen state court jurisdictions, and Lexington has some for about 10 systems. And there's definitely been a decrease for most state court systems, but really hard to quantify because they're all over the map. It could be somewhere between 7 and 8% depending on the court and the month. They look at month over month, 2019 over, 2020 over 2019. But in some, it could be 50%. And there were a few state court systems or state courts, like Delaware Chancery, for instance, that actually saw increases in filings and filings during the pandemic. So anyway, I just wanted to touch back on those two things. One, resolutions of cases, and two, state courts.
Thank you,
yeah,
David.
I think sorry, Charles, if I could just building on David's point about going to trial. I mean, I think that's spot on. When we always tell when we recruit people that, you know, we go to trial, we have hearings a lot, because when you're in international arbitration, our cases actually don't settle as often as cases do in litigation. And part of that, I think, is the friction point that Will was raising earlier. And I think it's a really good way of putting it, that the more sort of procedural friction you have in the system, the more opportunities I suppose you have to settle. And perhaps because arbitration is so flexible and the procedure can essentially be agreed by the parties or set by the tribunal, it does allow much more flexibility than a lot of state court litigation, even federal court litigation does. And I think that can help in reaching a quick resolution on some of these things. And you know, that of course depends on, you know, are you able to hold your hearing virtually? Because if for whatever reason the parties prefer to have an in-person hearing, or if the tribunal decides that a virtual hearing is not appropriate, then there's nothing unique. I mean, you still have the human problem that you would have in litigation as well. But the fact that the parties are able to craft the procedure to suit the case and to decide, well, you know, maybe we'll have it's much easier now to have a virtual procedural conference without, you know, finding time to get everybody in the same room for a first session of the tribunal. And I think that now there are of course disadvantages to the whole shift to virtual, as we've all been experiencing, I think, in our private lives as well, of doing everything remotely for a year. But I think some of the advantages of that shift will stay even after borders start opening up and vaccines are hopefully available to more countries around the world.
Thank you. Will, I'd like to turn to you, and can you tell us what you're seeing from a funder's perspective? In particular, I'm thinking about you're trying to deploy capital, you've got IRRs, I mean, you've got your financial concerns, and the changes must have impacted you pretty significantly. What can you share with us?
Yeah, sure. So yeah, there's probably a few trends that we can identify about what's happened to litigation finance. It's hard, to be honest, to know how much of this is driven by COVID, especially in terms of increased demand, because there was already a pretty strong and steep growth curve for funding. But probably three themes that I would highlight. First is demand. So we are fundamentally in the business of helping people pay their lawyers. And during COVID, people need more help paying their lawyers than they have before. And we've seen that, to David's point, in COVID-specific cases that have come on our radar. That would include both things like COVID insurance claims, but also bankruptcies, which are very much, you know, triggered in many parts by the economic fallout of COVID. But then also in kind of the garden variety cases, breach of contract, breach of fiduciary duty that we were already seeing. Anecdotally, our numbers have gone up, certainly in terms of the number of leads we've seen. But I also have a sense that you have more plaintiffs who are kind of picking their head up in the middle of litigation and saying, hey, I'm tapped out because of some larger economic event that happened. Can you step in, either for fees and costs or increasingly for working capital? The second point, to your point, Charles, is certainly the delay is an issue. There's definitely both a sense and a reality that the cases have taken more time to resolve. We've had things like hearings and trials just kind of pushed off. That's starting to pick up again now, though. There are a lot of trials that have been happening over the past several months. And then the third and final point is the world is flat again, I think is the way that I would say it, where historically funding really was something that was primarily done by lawyers in the cities where funders are primarily located, right? So New York, Chicago, Houston, LA, San Francisco. That I think has changed. It was probably going to change anyway, but I think Zoom, for example, allows us to have 4 meetings in a single day with people in 4 different time zones. And that's just more of a norm now than it was in the past. And so I think we really have seen, at least that validity funding become a truly national phenomenon instead of one focused primarily in a few.
That's fascinating. Well, I guess we can call that fund remote, goes along with work remote. So I'm surprised about that. I would have thought that the cities weren't such a focus, but thank you. Does anyone have a comment before we move to our last topic? If not, I will.
Just quickly on the internationalization of funding, to Will's point, we're seeing this in international arbitration as well, in terms of there has been for the past several years attention to funding in international arbitration, especially in investor-state arbitration, where there could be some specific dynamics. And just sort of 10 days ago, there was a working group of UNCITRAL came out with some proposals specifically to address third-party funding that would go in investment treaties between states. So, and of course, there have been task forces and whatnot looking at how financing in general is dealt with in the international space. So that phenomenon is very much, we're seeing that a lot in international arbitration as well, to Will's point.
Thank you. For our last topic, David, I'd like to turn to you. COVID has impacted lives and careers globally, and we all need to acknowledge the tragic loss of life and suffering, which is still ongoing. But for the purposes of this discussion, let's focus on COVID has impacted the culture of law. David, it's no secret that you not only had COVID, but had a very serious battle with it, and were intubated, and we're all relieved and glad that you are here with us today, of course. With that background, can you tell us how COVID has impacted the culture of law, career choices, and the human aspects of practicing law?
Yeah, so I think COVID has had a huge impact on lawyers' lives and careers, and I don't think we've even fully gotten our heads around it. I think that a lot of people have new visions for their lives and their careers, but they haven't necessarily acted on them yet, partly because, well, we're still somewhat in lockdown. It's hard to make a life change when you're in a period where maybe you don't want to be, for example, it's hard to switch a job. It's not ideal to join a new employer remotely. It's harder to get onboarding and training during these circumstances. But I think a lot of people have realized during COVID that they maybe need to rearrange or reprioritize certain things in their lives. So for example, in my case, at the time that I got sick in March of 2020, I was working mainly as a legal recruiter and just writing on the side. And as you mentioned, I had this terrible COVID experience. I was in the hospital for about 3 weeks, including a week on a ventilator. And as I was recovering, which was a long process, I just realized what was really important to me. And even though I enjoyed the recruiting and I really valued my colleagues at Lateral Link, which is the recruiting firm I was working with, I decided I just wanted to go back into writing. That was really my passion. And so I started this new website you mentioned in my introduction called Original Jurisdiction, which is what I've been doing full time now as of, I guess, May. But one thing that's also interesting that I'll flag on the issue of culture is what is going to happen with in the in-office work week. Law firms are now gradually announcing their responses, their reopenings, their new work from home policies post-pandemic. Some firms are really trying to return to that default of 5 days a week in the office. Others are saying, well, maybe it's going to be more like an expectation that you'll be in the office a majority of the time, or say 3 days a week, but there's going to be more flexibility. And so on the one hand, I think this is great. I think people really appreciate that flexibility, not losing time in a commute, not having to stress out if you have a childcare emergency or a doctor's appointment in the middle of the day and wondering everyone's going to be judging you for stepping out, FaceTime. On the other hand, there's a cost. I think that there is a real value to, in a collaborative profession like law, to being together with your team, to be able to have these casual mentoring opportunities. A partner walks past an associate's office and says, hey, I have an interesting case. Do you want to work on it? So there's a loss in collegiality and collaboration too. I actually just posted a story at Original Jurisdiction trying to sort of weigh the costs and benefits and invite people to comment on them. So it's really a question mark. I think it's going to be fascinating to see. But in many ways, the pandemic accelerated changes that were already underway. A greater openness to working from home, that was a trend that was already underway. The pandemic accelerated it. Law firms shrinking their footprints and going for smaller spaces when they renew their leases, that was already happening pre-pandemic. The COVID accelerated it. So it's really interesting to see what's going to happen to the culture of law practice and law firms as we emerge from this.
Thank you. Comments, thoughts? Well, Will, what did you do? I'd like to hear your thoughts on this, not only from a funder's perspective, but what do you think of law firm? It would seem lawyers can work remote, but I just heard today only 1 out of 10 job postings in the general workforce are stating that you can work remote. And a lot of folks, the article was an article about unemployment benefits, and people aren't ready to take jobs where they have to go into the office 5 days a week. What are your thoughts on that?
Yeah, great question. And there was another article recently that was saying employees are increasingly demanding that even if it's not full-time remote, that they're not in the office more than kind of 3 days a week. I think David put it really well. I think obviously all of this is in the context of all the horrible stuff that has happened globally due to COVID. I think lifestyle-wise, especially for a profession like the law, which has a lifestyle problem in many ways, at least for a lot of people, this will help, I think. I think it will be a benefit that people feel less pressure to, so long as they're getting their work done, not have to be in the office for 5 days. You do lose a lot, though. Before COVID, we would not do a deal with someone unless we sat down with them, had a meal, understood where they were coming from. That's really important. We haven't been able to do that. And then I think to David's point about seeing someone in the office, so much of trust and kind of the stickiness of life happens when you have conversations with people that are not precisely about the work thing you're working on. And it's a lot easier to do that when you're in person. So I'm confident that we're all going to find the right happy medium, but I don't think it's going to be 5 days a week in the office at most places.
I would think not. And Ina, do you have some thoughts on that? And then we're going to move on to questions from the audience.
Thanks, Charles. Yeah, I agree with everything David and Will have said. I've just sort of been reflecting on perhaps ever the optimist, but especially in what I do, one of the things that makes my practice so satisfying and rewarding is building lasting relationships with people from all around the world. And someone you might meet at a conference or someone who's hanging around the hotel lobby waiting for their flight might become a friend, a colleague, a client, someone who supports you over many, many years. So that has been difficult. On the other hand, as Will was saying, that stickiness, sort of seeing people as humans and as individuals, has in a way been, you get these little windows, whether they're 4 or 5 or however many you have on your screen, you get a window into somebody's life. You see their backgrounds, virtual or otherwise, you meet their kids, you can all commiserate over this sort of shared tragedy that we're all living through. And so I'd like to think that has helped offset a little bit some of what we've lost from not being able to look somebody in the eyes and share a meal and just get a feeling for them. And so I've been grateful for that, seeing clients, colleagues, and everyone around the world in their native surroundings, I suppose, and being more understanding that there is more to somebody's life than just the person you see in a conference room, I think is a valuable and worthwhile lesson despite the difficulties of the last year.
Well, that's very well said, and I hope that, I think we all hope that there is a more human aspect to what we do, and I would agree that I'm looking forward to seeing people in person again, but Zoom has been a great tool to get through this. It's time to turn to our questions from the audience, and we will be bringing people on stage, but I have a first question from David Wyatt, CTO at Cardware. What do you, for the panel, and I'll let whoever wants to tackle this, what do you think about the recent transfer challenges of Judge Albright, Western District of Texas, and particularly the maneuverings of Apple? So it's a pretty specific post-COVID question, but let me toss it out there.
I can take a shot at that. Maybe without getting into too specific in the ins and outs of the individual cases, but you've certainly seen a huge number of patent disputes that have been filed in the Western District of Texas, and Judge Albright certainly has gathered a lot of cases there. I think kind of 1 or 2 early cases went against Judge Albright, and I think he's won some since then. And so my guess is that you'll end up in kind of some equilibrium where most of the cases end up staying there, and a couple might get moved. But it's definitely clear that people want to file in Texas. Though interestingly, I think one trend we've seen is almost a little bit of maybe a reaction against that, and people saying, actually, we don't need to be in Texas because it might in some ways end up moving faster or be appealing in other ways in districts other than the Western District or Eastern District.
Thank you. Any other comments there? Well, we're going to move on to... Oh, sorry. Go ahead, David, please.
Oh, I was just going to supply the backdrop on that. I mean, it's really interesting. I think right now, Judge Albright has something like 20% or so of all new patent dispute filings like in the country. So he is getting a huge influx of these cases, and he's made clear that he likes these cases and he wants to handle them expeditiously. But of course, you have to make sure that there's a perception that, things are being done properly and with procedural regularity, et cetera. So that's just the backdrop for those of you who have not.
Well, I think we've lost David momentarily, but I'm sure he'll be back. Let me move on to the next question by Rebecca Beverly, founder and CEO, Avenue 33. It seems that despite the work atmosphere created by COVID, many new funds are on the market. What are you expecting with respect to competition in the litigation finance market in the future? Obviously, we're going to start off with Will, but I'd like to also hear from Ina.
Yeah, would love to hear what Ina has to say too about being on the lawyer side. It's a great question, Rebecca. You've definitely seen more funders come in the market. It's an interesting question about whether, if there had not been COVID, kind of but for COVID, whether there would have been more or less. I think there's probably an incumbent advantage, right, where you have those relationships in place, especially where you're just trying to meet people for the first time in the fund without people to kind of sit down with them. I think there's definitely more competition. I think that's a good thing. Welcome that, because the challenge is to kind of double down even more on the values that we have of fairness and transparency with respect to the fines, but there's more of it for sure.
Ina, can we get your thoughts?
Sorry, my computer's being slow there. Mercury is still in retrograde, I hear. Yeah, I think that's right. I mean, there is a lot of competition. I mean, there always has been in a way, and especially in what I do, both for treaty and commercial arbitration, the players are quite sophisticated, and so clients understand and counsel understands that financing is not just, we're not just in the paradigm of, the bankrupt company that just doesn't have liquidity it needs to bring the claim. There are all kinds of, clients are really starting to see financing as a much more sophisticated balance management tool, right? And helping them achieve other business objectives as well, which I think will become even more important when there is a market disruption like we're going through now. So in a way, there is more opportunity as well. So because the framework of it is not just a client that needs, X million dollars for a specific arbitration, but also working creatively with a funder in order to achieve a business goal of some kind, and thinking how the funder can support the client in its business. Those kinds of conversations, I think, again, anecdotally, but we're in, because of the disruptions that the markets have faced, there are more opportunities for those kinds of conversations. And at the same time, I get the sense that there is an awful lot of money out there, and and funds are looking to invest it in more creative ways. And distressed assets there's always been one way of doing it, but these international claims, and not just claims, but also monetizing awards or other ways of doing it. So in a way, the sense is that there is more competition. That's because there's more opportunity, and in a way there's more demand for thinking more creatively. And so that creates, I think, both a challenge and I suppose an interesting opportunity for shops like Validity to distinguish themselves in what they're offering, because it's not just money's money. It's fungible in a way, but when you have a more sophisticated business challenge, that's where it's quite exciting from the counsel's and the client's perspective to have that choice and to understand who is the best long-term partner for this case, and beyond just the financial aspect of it.
Thank you. It certainly seems like there's going to be a lot of robust competition. I'd like to bring someone up to the stage. I think we have Gene Phillips here. Let me see if Gene, you should have the mic. Hopefully you have your camera on. We can see you.
I have my camera on, but you can't see me for some reason.
All right. Well,
I'll ask my
please.
question anyway.
Yes, please go ahead.
Thanks, Charles. Thanks, panel. This has been terrific. You've done a nice job of explaining the changed nature of litigation, maybe the movement from the courts to arbitration, well, at least the trial courts to arbitration courts, or at least the increased interest. Can you talk a little bit about any changes you may have seen within the arbitration courts themselves, whether it's about speed, whether it's about a change in nature of process, or cost? I guess cost is very important as well. Anything that's jumped out in the last year or so as a result of the change and the increased demand?
Please go ahead. Anyone want to handle that? How about David? Why don't we start with you?
Sorry, you lost me a little earlier. I was going to actually defer to Ina. The speaker was curious specifically about arbitration courts and how they've changed. It sounds from her earlier remarks that things have certainly gotten a lot busier. And I think that it does raise an issue as to the civil justice system of whether, folks or entities with more money can essentially buy better or at least faster justice. I think that is one issue to consider, but I really would defer to Ina with her expertise on how arbitral forums have changed in the past year or two, if they have.
I'd have to give some more thought to exactly. Jean, perhaps could you explain your question a little bit more? Because arbitration, because it is a creature of contract, parties can choose the rules that govern their proceedings, and those rules are typically chosen at the stage of the contract itself. So I'm not sure if that helps answer your question.
No, sure. But you might have increased demand for arbitrators, and the good ones. There might be more people looking for certain parties, and others knowing that that the litigants are maybe desperate to move to arbitration, and that they are the chosen few, might lift their fees. They might be more difficult to get, let's say 7 days worth, or however long you need. That's on demand, timing, cost. Processes can change as well within the arbitration forums. They might relax procedures, maybe to speed things up. I don't know that I can say that across the board, but I'm interested to hear if there are any trends that you've noticed.
I don't think so from that perspective, I would say, because again, the arbitrators' fees are set by the institution, so there's not typically any sort of pressure from the parties on that sense. When you're under institutional rules, there is either a sliding scale or an ad valorem scale, or some combination of the two. So the arbitrators who are in demand will always be in demand. The question is, will they be perhaps slightly more available because they don't have to travel to the other end of the planet to hold a hearing? So I suppose that's what I would say on that question.
Okay, thank you.
I think you're on mute, Charles.
I think you're muted, Charles.
Charles, I think you're on mute.
All right. Well, I think
Wendy, perhaps while we're waiting for Charles to go on, I mean, one of the topics we've discussed a little bit, and we can chat about that while in the meantime, I suppose, is sort of moving to virtual hearings and the pros and cons of that, because I see there's a question about that as well in the chat, so maybe we can take that one while we're waiting for Charles to come back with us. And we've been talking about some of the advantages of virtual hearings, but there are also and this is a topic that we've focused on a fair amount in arbitration, and there was even a widely reported case where a hearing had begun in person and the country shut down, so they had to switch it to a virtual hearing in the middle of the hearing. In our practice, we've probably done about one evidentiary hearing or some other kind of argument every couple of weeks, so it's certainly been busy from that perspective. I think that is one of the biggest changes that we've seen, that transition to holding hearings and argument virtually. And we had to shift quite rapidly to this sort of new paradigm. And I'd be interested to hear what people's experience of that has been with the court system, because arbitration is by no means unique in holding remote hearings. But like most things in the field, there are now half a dozen protocols and task forces and model procedural orders, and it sort of comes second nature to all of us. We now all have our template virtual hearing protocol, and it's been a good iterative process where everybody has something that they've learned, a lesson learned from the last time they did one of these. So it's sort of it feels like an incremental improvement in the worldwide community as we're all building on each other's experience. And so we have several protocols. CIARB has issued a guidance note. We have the Seoul protocol. We have the Hong Kong guidelines for virtual hearings. The ICC has its, and ICSID have their own model protocols. But it is important, I think, also to bear in mind some of the real disadvantages that can come from that. First of all, due process. And so, again, there's been some studies and ongoing projects to look at whether there is, in fact, a due process right to an in-person hearing in each individual jurisdiction where an arbitration may be seated, which will be an interesting project. it can actually be less efficient in some cases for cross-examining witnesses, or parties can be concerned that it will be less efficient. When you have internet stability issues, for example, and you lose your witness in the middle of a cross-examination. And I think we've all been, and we have to be, right, going back to that sort of human aspect of things, we all need to be understanding that this happens to the best of us, and you can have 17 different run-throughs and technical tests and redundancies, but it's going to happen. That's sort of learning to deal with that.
That's well said. That's well said, given that I was in limbo for about 5 minutes, but I'm back, and we're going to transition right to networking now that I've been able to restart everything here. So Wendy, thank you again for inviting me to moderate this panel. And if you can take us to the networking, I would greatly appreciate that.
Sure. Thank you, Charles, and thanks to the panelists and our audience members for that very wide-ranging and insightful discussion. So now we're starting a few minutes late, but we're going to transition to the lounge, where we'll all have the chance to connect with one another. When we get to the lounge, you'll see two options. You can select one, the speed networking option up top, where you'll be automatically matched for 3-minute speed meetings. Or below that, you'll see our table chats, where you'll be able to join any of the tables. You can even hop around from table to table if you want. You'll see some theme-based tables, as well as a few tables with our speakers' names on them, where each of them will be seated to answer any additional questions you may have for them. We'll even have a couple of audio-only tables for those of you that prefer to stay off camera. So we have a shy audience today, but that's okay. We'll see you guys once again very briefly at 12, when we'll bring you back here to end the program. And for those of you that need to leave before then, thank you so much for joining us for this first event in our Dealmakers Disruption series. Thank you to our sponsor, Validity Finance. And don't forget to register for part 2 of this Beyond COVID series, where we'll dive into IP litigation trends and insights on litigation funding in that area. Okay, well, with that, I will wish you all happy networking, and we'll see you in the lounge.